Okay, this paper has developed out of conversations and some empirical studies that John Darley, who is here, and Rob McCune, who you already know is not here, and I have engaged in over the last several years now, thinking about a number of instances in which decisions that mock jurors make seem odd when we think about them through the lens of the traditional legal system and the purposes that the law suggests jurors ought to be pursuing when they make their decisions, but that perhaps they don't appear quite so strange when one considers them through the lens of how psychologically jurors might be making their decisions. So first, traditional models of legal decision-making presume, at least implicitly, if not explicitly, that jurors and other fact-finders are willing and able to adopt the goals of the legal system. And to make decisions that are consistent with those goals. So each legal decision, whether it be a liability decision, a decision about compensatory damages, a decision about punitive damages, has different legal purposes. And the law assumes that jurors can adopt those purposes and goals underlying each of those decisions separately as defined by the law, and will, to the extent possible, ignore other goals that they might have in making those decisions. And this view of sort of a single motive juror underlies a lot of different legal rules that assumes that jurors can compartmentalize the different motives and information they have and make independent judgments. Okay, so, for example, jurors are asked to isolate their reactions from extra evidentiary information from their evaluation of the trial evidence. So they're supposed to ignore pretrial publicity, ignore inadmissible evidence, and so on. They're asked to use certain evidence for some purposes but not for others. They're asked to reach independent verdicts on multiple claims, sometimes in a single trial for multiple plaintiffs and or against multiple defendants in a single trial, and to do them independently. And they're asked to compartmentalize their liability, their compensation, and their punitive damage decisions so that they're expected to be driven by a motive of, say, causal accuracy when determining liability, driven by a plaintiff-focused motive on compensation when making a compensatory damage decision, and on defendant-focused motives of deterrence and retribution when making punitive damage decisions. And so they're asked to separate these decisions and pursue different objectives with each of them, and may be asked to consider certain evidence as relevant to only one of them, but not to others. So, for example, defendant wealth might be relevant to a punitive damages decision, but not to a liability decision or a compensatory damages decision. Okay. In a similar way, economic models of legal decision-making also tend to presume that jurors can pursue unitary objectives, for example, a focus on achieving optimal deterrence. However, there's empirical research in psychology, primarily mock jury research, which suggests that jurors have difficulty with all of these things, that they can't compartmentalize these decisions, and in fact, under some circumstances, will conflate the decisions and the objectives of these various goals. Okay. So, in contrast to these sort of single motive models, we want to suggest that jurors and other finders of fact attempt to use their verdicts to satisfy numerous goals simultaneously. Okay? And they're not always skilled at separating out and following the goals determined by the legal system. So they may, at the same time, be trying to reach a verdict that's consistent with the evidence that's presented at trial, and often they are able to do that. They may be trying to achieve distributive justice, either by assessing liability proportionately with fault, a sort of fault-based system, and or by allocating resources to each party in proportion to that party's need. They may be trying to appropriately compensate plaintiffs, neither undercompensating or overcompensating. They may be trying to effect deterrence in some measure. They may be trying to exact retribution. They may be trying to come to a verdict that's consistent with their beliefs in a just world or their beliefs about individual responsibility. They may be trying to restore an appropriate moral balance between the parties. They may be trying to express symbolic values about wrongdoing. They may be trying to comply with economic logic. They may be trying to follow and reconcile the judge's instructions to them. And they may be trying to satisfy other practical concerns like finishing the trial and going home to have dinner with their family. And you can probably think of a number of other kinds of motives that might be behind what jurors are trying to do. So while civil jurors are trying to do some combination of any of these goals, their task that they're given to do only affords them some limited mechanisms by which to satisfy these goals. Generally, they'll have a liability decision they can make and a compensatory damages decision, and sometimes they may be able to make a punitive damages decision. So we want to suggest that these mechanisms are interrelated with these kinds of goals in some complex ways. And we propose a set of goal management principles that jurors might use to help them manage potential conflicts between the various goals. So first, the principle of equifinality holds that some goals may be alternately satisfied through multiple pathways. So for example, while compensating a plaintiff is most straightforwardly achieved through compensatory damages, it's also possible that jurors could use their punitive damage award to achieve compensation. Okay. Second, the principle of best fit suggests that some pathways are sometimes better at fulfilling some goals than are other pathways. So for example, compensatory damages may better serve compensatory goals than they are at serving retributive goals. Requiring a wrongdoer to apologize may serve some expressive goal, but probably isn't the best way to achieve economic compensation to the plaintiff. Third, multifinality suggests that a particular pathway can accomplish multiple goals at the same time. So requiring a defendant to pay money to the plaintiff may serve to compensate the plaintiff and may at the same time educate the defendant and other people about what's unacceptable conduct. And finally, the principle of goal incompatibility holds that some objectives will be difficult or impossible to satisfy concurrently. Okay. So for example, a particular punitive damage award may be thought to appropriately punish the defendant, but may be thought to overcompensate the plaintiff. And the juror will have difficulty accomplishing both of them effectively with the same decision. So the challenge for jurors is to come to a verdict through the limited means that they have to reconcile these different goals given these goal management principles. And before I suggest a model about how jurors might psychologically do that, I want to elaborate briefly on some goals that research in psychology suggests that jurors might be attempting to satisfy, sort of beyond the traditional compensation deterrence sorts of goals in the legal system. So first, distributive justice. Jurors may be attempting with their verdicts to satisfy different conceptions of what it means to achieve distributive justice, that is, different norms for how resources are allocated. In general, the law is intended to operate following a model of distributive justice based on allocation of fault. We'll hold someone liable when they've committed an intentional wrong or something that we've determined to be negligent. So consistent with this traditional doctrine and with the norm of equity, some of Rob's prior research has found that jurors strongly endorse the notion that verdicts should be based on fault, such that the agent at fault should be the one who bears the cost of the injuries. Okay. An alternative distributive justice norm is based on each party's need. So consistent with this norm, Rob found that the second most commonly endorsed goal of mock jurors was to help needy plaintiffs obtain compensation. Okay. So jurors may hold the defendant responsible in order that the plaintiff may be compensated for his or her loss without so much regard for the defendant's fault. Okay. And this notion helps to explain the findings of some empirical studies that have found a relationship between the severity of the injury to the plaintiff and civil liability judgments. And some studies have found this relationship, others haven't, and there appears to be a relationship there, although it's a very small one. Okay. So different conceptions of distributive justice may be competing for the juror's attention. Second, jurors may have more symbolic goals in that they may attempt to express through their verdicts support for important values that they hold and to make statements about those beliefs. So civil jurors who hold the defendant liable for a civil wrong, who require the defendant to compensate a plaintiff, and or who award punitive damages, make statements about what behaviors are deemed acceptable and unacceptable in society and about the appropriate relationship between the parties in the case. Specifically, jurors may attempt to use their verdicts to symbolically affirm core values that they believe have been threatened by the actions in the case. So Tetlock proposes a sacred value protection model that provides evidence that in the face of a perceived threat to some central belief, people will respond by attempting to distance themselves from the offense, from the behavior that has led to that threat to the values, and with a response of moral outrage that will manifest itself in negative attributions and evaluations of the people and behavior that have intruded on the closely held value, with negative emotional responses such as anger toward those individuals or entities, and with greater support for the punishment of those who have threatened the moral norms that they hold closely. One type of threat to sacred values occurs when decision makers entertain what are thought to be illegitimate comparisons between things that in some sense defy comparison. Okay? So in their theory of taboo trade-offs, Fisk and Tetlock suggest that there's particular resistance to applying market pricing to relationships that fall into some other kind of relational domain, such as based on equity or equality. And especially prescribed are those trade-offs that treat sacred values like honor and love and justice and life as fungible. Okay? So exchanges of money for things like votes or babies or love or things like that strike a lot of people as distasteful and morally offensive, and you might expect this response of outrage and moral distancing, moral cleansing. This theory helps to explain recent empirical evidence by us and by others suggesting that civil jurors may be more punitive against companies that undertake cost-benefit analyses in making safety decisions than they would be against those who did not engage in those kinds of analyses. So, for example, Viscusi has found that jurors appear to be more likely to award punitive damages and to make somewhat larger punitive damages awards against companies that conduct cost-benefit analyses. Okay? If jurors were primarily concerned about motives like deterrence, that would seem to be an odd result. Okay. And I'll just put up a picture of some of our data that speaks to this. We find similar results when in this condition, jurors were not told anything about what the company might do in making its safety decisions in terms of thinking about costs. The middle bar is a condition where we said the company considered the costs and gave information about what the costs, the potential safety costs of the decision were. And in the third bar, we told jurors that the company had explicitly conducted a cost-benefit analysis. And you can see in the latter two bars that a higher proportion of jurors decided to award punitive damages against the company. So when the company explicitly considered costs, whether or not it was in a formal cost-benefit analysis, more jurors award punitive damages. Okay. Now, if this holds up, and I know Steve is doing additional research in this area, there are several possible explanations for why we might get this pattern of findings. One that we find particularly compelling is that when corporations put a price on human life or safety, or trade money off against life or safety, they're engaging in a taboo trade-off to which jurors react with dismay in attempts to censure the corporation for having entertained that trade-off. Okay. So consistent with this account, we find that when the company considers the costs of the decision, jurors report experiencing greater outrage in response to the defendant corporation than they do when there was no suggestion that costs were explicitly considered by the company. They also find the outcome to be more foreseeable when the company has considered costs, but it appears that the outrage reaction is what mediates the effect on the decision whether to award punitive damages. There's not a correlation between the foreseeability ratings and the award of punitive damages. Okay. So it's possible that by punishing the corporation through a punitive damage award, jurors were able to morally distance themselves from what they found to be a distasteful trade-off and to symbolically restore the value that they place on life and safety. Another set of goals that civil jurors may seek to fulfill are similar to these value-expressive goals. And philosophy, as well as equity theory and social psychology, suggest that jurors may attempt to express support for the value of the victim of the wrongdoing. So the theory is that when a wrongdoer engages in behavior that does not appropriately respect the value of the victim and the relative worth of the victim and the wrongdoer, it creates a moral imbalance between the parties. So it goes, I can be negligent at your expense because I value you less than I value my own self and my behavior. Given your lesser worth, I can treat you in this fashion. If this is true, then civil sanctioning is one way of attempting to reestablish the equity between the parties and to symbolize the correct relative value of the wrongdoer and the victim. Thinking of jurors as attempting to restore moral balance helps to explain findings of studies by Rob and his colleague Michelle Anderson, where they looked at what the effects might be of statutes that award punitive damages to the state rather than to the plaintiff. Participants were asked to award both compensatory and punitive damages in a civil case, but the recipient of the punitive award varied across the cases. So when the punitive damage award was to go to the plaintiff in this first bar, more participants were inclined to make a punitive damage award than they were if the state was to be the recipient. Okay. Because participants had already had an opportunity to compensate the plaintiff for her injuries, Anderson and McCune suggested that perhaps the punitive damage award serves a symbolic restorative function that is dependent on receipt by the plaintiff. That is, a punitive damage award that's specifically required to be paid by the wrongdoer to the injured party may be better at affirming the appropriate value of the injured party relative to the wrongdoer. Okay. Now, while the payment of money, say through punitive damages by the defendant to the plaintiff, may sometimes serve the expressive purpose of reestablishing respect for the victim of wrongdoing, it's possible that it may not always be the most satisfactory pathway for accomplishing this goal, which implicates the principle of best fit. This may be one way, there may be other ways that are more appropriate. One alternative mechanism by which the appropriate moral balance can be restored is by an apology given by the wrongdoer to the victim. Okay? Because we were concerned about how jurors make these decisions and what the goals of jurors might be, as part of a larger study, we gave some participants who had descriptions of civil cases the opportunity to require the defendant to apologize to the plaintiff as part of their verdict. Okay? So in addition to decisions about liability and damages, they were given the opportunity to indicate whether they would like to require the defendant to apologize. Across the two different cases that we used, the cases were set up to elicit liability judgments, so 90% of the participants found the defendant liable, and of those participants, all of them chose to require the defendant to apologize to the plaintiff as part of their verdict. So despite an intuition that this kind of coerced apology is inherently insincere, right? And even after they'd had the chance to express their distaste for the behavior through their liability verdicts and through their damage awards, these mock jurors indicated a desire in addition to compel the defendant to offer an apology. So even after they've sort of served potentially their deterrence goals, their compensatory goals, and even in some measure their expressive goals, they wanted the apology. This suggests perhaps that requiring the apology was a better pathway by which they could restore relational equity between the parties than were their formal findings of liability and damages. To the extent that the transgressor's wrongful conduct has conveyed a message that the victim is considered by the offender to be beneath him, the apology, perhaps whether it is voluntary or compelled, can serve as a degradation ceremony that restores equal footing between the victim and the offender. So when jurors require an apology, if they were allowed to do so, they might be sending a signal to the offender and to the victim that the victim is valued and defended by the community and can't be treated in a fashion that diminishes her worth. Okay. So these are just a few examples where jurors might be attempting to pursue goals that aren't the traditional goals expected by the legal system. And we suggest that any model of juror decision-making that focuses on any individual motive and ignores the variety of motives that jurors might have is likely to be inadequate. So a model that focuses solely on deterrence is likely not going to capture the picture of what jurors are doing. Similarly, a model that focuses simply on expressive goals isn't likely to capture everything that jurors are doing. So we propose that instead juror decision-making might profitably be conceived of as a process by which jurors attempt to satisfy multiple goals simultaneously. That is, as a process of satisfying constraints and conflicts between the goals in parallel. And this can be represented by connectionist models. These are models that attempt to simulate situations in which the decision maker must integrate numerous related elements that may or may not be consistent into some coherent whole. So when decision making is thought of as a constraint satisfaction network, the factors related to the decision are conceived of as elements or nodes in some neural-like network. Okay, so each of the factors, and these might be propositions, pieces of evidence, goals, actions, etc., are conceived of as goals, and they are linked to each other by connections that are valenced, indicating the extent to which the elements constrain or reinforce each other, and are weighted in indicating the strength of the link. And I want to give you a sort of more concrete example about what this might look like. Okay. So in a simple sense, say we've got a piece of evidence, we've observed A hit B, and we've got two potential interpretations for what happened. It may have been a violent blow from A to B, or it may have been sort of more friendly jab on the shoulder. Okay? Either of these explanations can be positively linked to the observed behavior, so the solid lines represent a positive link, but it's unlikely that both are going to be true at the same time, so they're represented by a dotted line which represents a negative link. And the task of the decision maker is to make a decision about which of these explanations is more plausible. Okay? And we might add information to our model. So we find out that A is angry at B. That is consistent with the violent strike, not consistent with the friendly jab. Okay? Now, in a parallel constraint satisfaction model like this, the model starts out by assigning each element a small but equal activation. So we might activate each of these elements at something 0.01, say. Okay? And the links between them would have different strengths, possibly in addition to the positive and negative valences. Okay? The central aspect of the model then is that the activation level of each element is updated simultaneously based on an equation that factors in the number of elements connected to that element, the level of activation of those elements, the strength of the links connecting the elements, and the valence of those links. So if we add in this element, it's likely to make our acceptance of the violent strike interpretation more highly activated, and we're more likely to accept that interpretation of what we've observed. Okay. The elements in the model are reevaluated simultaneously over and over until the values of the elements cease to change. They stabilize, and we're able to select which coherent explanation based on the final activation of the elements. Okay. Now this basic model is a useful model with which to understand juror decision-making in a couple of different ways. First, this kind of model is particularly useful for understanding how jurors select a story that represents what happened in the case that integrates the numerous pieces of potentially contradictory evidence presented at trial. Okay. As applied to juror decision-making, then, the elements in the model are the evidence presented and propositions, explanations, or hypotheses about how this evidence all fits together. The links between the elements are based on the relationships between the propositions. And then jurors would choose the account or story that has the best coherence as indicated by the final pattern of activation among these elements. Okay. This process is consistent with psychological understanding of juror decision-making, in particular the story model of juror decision-making, in which jurors construct and evaluate narrative stories of the events at issue and match that story to the appropriate verdict. Okay? Under the story model, a more coherent story is more likely to be accepted by jurors, and this sort of formal connectionist modeling provides a formal structure for the mechanism by which the coherence of the stories is evaluated. More importantly for our purposes is a second way in which these kinds of models are useful to understanding juror decision-making, in which decision-makers are evaluating potentially inconsistent goals and selecting actions, that is, selecting verdicts to perform. So in the context of civil decision-making, we suggest that jurors attempt to come to a decision that balances multiple potentially inconsistent goals and fits within the constraints of the legal decision-making task, that is consistent with the jury instructions and maps onto one of the verdict alternatives that is available. So just as the parallel constraint satisfaction model of explanatory coherence frame the way in which legal decision makers map the evidence onto a coherent story and match that story to the verdict options, we propose that parallel constraint satisfaction models of deliberative coherence can frame the way in which legal decision makers map their goals onto the available verdict options. The elements then in this kind of model are the actions and the goals that the jurors have available to them. The links are based on the degree to which the actions facilitate the goals that the jurors have and the degree to which this is so. So a model about what this might look like when jurors are attempting to, say, decide between two monetary awards, one of $10,000 versus another option of awarding $100,000. I've only put four goals up here for simplicity's sake, but they want to deter the defendant, express disapproval, cover the plaintiff's expenses, but not overcompensate the plaintiff. Okay? And it's useful to think of the links between the various elements in the model as implementing the goal management principles that we described earlier. So a goal might be connected by positive links to more than one action. That would be the principle of equifinality. So a juror that wants to cover the plaintiff's expenses might think that either of these awards would be sufficient to do that. It's possible to achieve that goal through either of the two considered actions. Each possible action might be connected by positive links to more than one goal. That's the principle of multifinality. So this particular action, $100,000, may at the same time deter the defendant, express disapproval, and cover the plaintiff's expenses. Okay. The links between a goal and several different actions may have different valences. That's the principle of best fit. And you might think that, well, either award would express disapproval of the defendant's actions. Perhaps the $100,000 award better expresses that disapproval than the $10,000 award. Okay? And finally, incompatibility. Some of the links between two goals or between two actions may be negative. That means they may be inconsistent. It's not possible for the jurors to award both amounts. They've got to choose one amount to award. Okay? So just as different accounts of the events in a case compete for acceptance by the jurors, so too jurors have multiple goals that compete to be satisfied. Verdict options, liability, compensatory and punitive damages, and apologies, if they were available, might be used for civil jurors in their attempts to simultaneously fulfill these compensatory, expressive, punitive, deterrent, distributive, moral cleansing, etc. goals, along with other normative and non-normative goals that jurors might have. And we propose that conceiving of jurors' decisions as outcomes of these attempts to satisfy these multiple potentially competing goals in parallel provides a useful model for more thoroughly understanding how jurors come to the decisions that they come to.
I know you're hungry.
Yeah.
Maybe I'll move on. I'm a psychologist, and this is my first legal conference, and I've noticed your quaint, wonderful tradition of thanking. Not that we psychologists are rude, but we just have so much to say. Anyway, I am really delighted to be able to speak to these three great papers that have so much fascinating emotional material in them that I think that I can address through some of my own work also. I believe I was invited because I wrote a book on blame in 1996. Prior to that, though, I also did work on early moral development of children, the beginnings of morality in the ages 1 to 2. Work on victims and how we perceive victims in an edited book called New Versions of Victims. And most recently, I worked with Geoffrey Murphy, philosopher, on forgiveness, or I guess I should say against forgiveness rather than on forgiveness. But today I'm going to, this is just to let you know why I'm picking out what I pick out from these three various papers. I'm going to begin my comments focusing on the last paper, the goal of value expression and protection that jurors are fulfilling in their judgments. Speaking to the issue of our need to express condemnation for certain events, and hopefully drawing together points made by Tony, and hopefully, if you give me the 5-minute sign, then making it all relate to your paper on whiplash victims. First, let me start as a philosopher with defining condemnation versus judging, because I think I'm using Roger Wertheimer here, who says that judging would indicate a disapproval from the jury, and yet describes much less emotional involvement. The jury who judges cares not whether the wrongdoer suffers or learned a lesson. Condemnation, though, not only expresses disapproval, but ensures that the wrongdoer feels something, usually bad, sometimes remorseful, and often very ashamed. Now, condemning serves a social function. As noted in the paper we heard, condemning expresses to society that we, as moral human beings, don't do that in our society. We abhor that act, that way of thinking, that lack of feeling, and to quote you, it undercuts our image of ourselves as moral human beings. Condemning also makes a claim of objectivity and impersonality. Once again, I'm using Wertheimer here. That we're condemning on behalf of some larger universal moral principle. It's different than vindictiveness or vengeance. And condemning can be assaultive. We may want to watch a defendant swerve or show some visual sign of suffering. But this also can be social, as you understand deterrence. And to make a symbolic act that these kinds of acts won't be tolerated. So generally speaking, condemnation is quite unrelated to rehabilitation, which we haven't heard much about today. It's not done for the wrongdoer's benefit. In fact, it's pretty much a wholesale rejection of the person, not merely the act. And this kind of judgment, a condemnation, is what seems to be called for in cases of incommensurability. In cases of incommensurability, the wrongdoer seems quite separated from social norms. How could he have put such a price tag on human life? This is what was referred to as taboo trade-offs. How could she sell a baby? Because these acts are so at odds with human decency, we as jurors, and identifying the jurors, look to condemn them. We have a problem then seeing the wrongdoer as a person, or as much of a person as a victim is. And as the author suggested, this may be our attempt to even out a power imbalance, to redress this imbalance by saying who is more important than who. And when you see a wrongdoer as less of a person, though ironically still as an agent, it's easy to require exorbitant awards. They can be condemned more easily. And as Tony spoke of trends towards the diffusing responsibility, if we can see a person as a representative of some alien or huge structure rather than an individual person in that way, we can then ask for greater awards and see the person as less of a person. Now, even though juries make this symbolic statement of condemnation to serve a social goal, I want to suggest that it perhaps serves more personal, vindictive goals, and that the private is never so separated from the public as these acts of incommensurability that seems so outrageous to us suggest. And that is because these acts evoke in us some early and most primitive fears. Now I want to go beyond Freud now and talk about object relations theorists, something that sort of came out of Freudian theory, but it's a different, a newer form of psychoanalytic theory, which suggests that our earliest response, our earliest fears and our needs have to do with the mother-child relationship and issues of caretaking, of safety, and the importance of that earliest relationship to provide security and safety, an experience of going on being, of trust. And actually, I think that's why we're so morally outraged at the Catholic Church right now, because religion in our culture serves this function as a representative of that early trust relationship between mother and child. But in summary, our urge to condemn, to make someone suffer, to get even, speaks to an emotional hurt that needs soothing. And when someone or some company who is supposed to care for its customers, or a government that is supposed to nurture and support, when any of these people and whom they represent symbolically don't do that, we want to make a symbolic statement that they should have, but they also become a target for our most aggressive feelings. They become the bad parent that must be destroyed so that a pleasant fiction of a secure world is restored. So hence, condemnation in the sorts of cases we've heard today, in the guise of impartiality, serves a very primitive goal of punishing the bad parent. It also serves to reinforce a profoundly human expectation that everyone should be cared for. So and when this is challenged, because this lack of protection is so threatening to us that those with power over us couldn't care, could put a monetary equivalent to our safety, we're more inclined to punish, and we're more able to do what's called sort of a primitive defense mechanism. We're inclined to split. And when you split, it's a primitive urge, the need to be taken care of, and a primitive defense is splitting. And when you split, you see someone or something as all bad, and the other as all good. And I think in part that explains for these exorbitant awards. The wrongdoer becomes a projective screen for evil, in which the other can be good and the wrongdoer can be seen once again as not us. Now lawyers know this well because they're constantly trying to make wrongdoers into people who are more human. That's why families, I think, are brought into the courtroom, because you want to express to a juror that this person is also a caretaker, can take care of. And I think that has the effect of addressing that primitive worry. But in acting out of this condemnation, there are costs to the culture. And what's missing, ironically, is the caretaking of the criminal. The rehabilitative ideal that we've so much forgotten reminds us that if we want to condemn others for not caring, we need to support larger goals of caring for every individual. If not, then judgments are about vengeance and less about restoring relationship and moral order. A second problem is that Geoffrey Murphy reminds us that vengeance is almost always impossible. It's hard to get even. And so that condemning those who have hurt us only partially helps restore relationship. It addresses the relationship between the wronged and society, but not completely enough the wrongdoer and society. So I want to briefly talk about forced apologies right now, because I'm very interested, though not a complete advocate of it, and I know from the paper that it might even not be constitutional to require an apology. But the idea that a forced apology is insincere is not quite a complete explanation, because underlying that is our cultural belief that emotions are spontaneous things. But anthropological work, social constructionists would argue that in every culture we make possible the spontaneous feelings of emotion, the spontaneous expression of feelings by creating circumstances under which those feelings can be expressed. So the wrongdoer in the court, whether it's a doctor in the malpractice suit, or an accountant for a company, or a CEO who did the cost-benefit analysis that jeopardized the safety of millions of people, if given a ritual of apology, may be given a socially sanctioned place to express something that he may have felt deeply, or may have just had 1% of a feeling of. And if given this ritual, may indeed be moved to experience the wrongdoing as something he has responsibility to another individual for. So the role of apologies in the taboo trade-off is to say that this other is not alien. This is somebody who is one of us. This is a person who is capable of being influenced by the world in the right way. It also makes a social act an individual one, saying this is your fault and this is the person hurt. And why do we need to make this kind of act an individual one? One, because the individual integrity of the victim was hurt by the act, but also because we're kind of a People magazine culture, and it's difficult to blame that culture of greed or that systemic responsibility that was advocated. And even along the lines of commensurability, that to restore some sort of moral order based on caring, it seems odd to only make a person suffer by paying a huge sum of money. I mean, isn't that ironic? We get more socially from making him care, not only making him suffer, but making him care. However, I totally understand that in this sort of forced apology, there's an element within us that wants to shame the wrongdoer. And this is something we need to be cautious about. Now, this brings me to the studies on whiplash. This excellent work on making the victim and his or her pain more visible and more authentic to suspicious jurors. What I wrote about in the book, New Versions of Victims, was the idea of victim performance, that it's sometimes implicit and it's sometimes very explicit. Lawyers give explicit instructions. I'm not sure they're allowed to, but they give explicit instructions on a kind of performance on the stand. Amanda Conradi is a social psychologist who did work with rape victims before trial, and they almost all spoke of practicing being able to cry on the stand, and of downplaying any aspect about the personalities that showed strength or independence. For example, there was one woman who was an avid backpacker who didn't get had a hung jury the first time, and so during the second trial, she hid that fact from the jury so that they wouldn't see her as such an independent or strong person. But it's not just a performance. These people are playing roles for us, roles that we as people want to hold dear, and these roles are victims and perpetrator. And we want our victims to be truly victims, innocent, damaged, and good. And we expect them not to be demanding, not to be angry, and definitely not to be in it for the money. So paradoxically, if a good victim stands up for her rights, she's no longer a good victim. She's strong in terms of our expectations. A victim then must reluctantly take the stand, must express humiliation. So in the whiplash studies, you have a victim who's saying, I deserve something. And in this particular mock trial, I read the whole transcript of the mock trial. And what they do is they pit harm against harm, because what that mother is doing isn't just reaching behind and shushing her kids. She's preventing her son from hitting her daughter. Okay? It's a small harm, yes, but she's doing what a mother should be doing, right? She's fulfilling the role of mother. She's disciplining her children, and they're pitting. It would be different if somebody was reaching down to get a beer, and then, right? Or even a cassette tape. It's something different. So what they're doing is they're pitting one harm against another. And I would suggest here that that's why negligence or lack of care is harder to prove, because that primal fear is harder to evoke here, because this person, a mother, was in our moral order, as any of us might do, who are mothers, take care of our children, and how any of us might expect our mothers to act. And the best way to have a victim understood by a jury then is to play on our notions of what a victim ought to be. Reluctant and only in court because his doctor persuaded him or someone on his behalf urged him to take the stand on his own behalf. In this way, you evoke in juries that primal urge that stems from the mother to the child and that everyone must be cared for. I'll end here because I'm eager for discussion and I know people are hungry too.
Well, and I can't resist one comment, which no one has to comment on, but which I just would like to throw out, which is that all of this has been fascinating, and I wonder how our society is dealing with the fact that the number of trials keeps going down, 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 percentage-wise, and all of these expressive factors that people have been talking about really no longer often have any outlet whatsoever. But I will call on people in terms of questions. Yes?
I'm wondering, you have been getting discussion here about the concept of forgiveness in this process, and I'm just wondering if there is any room in the system of forgiveness, and I'm particularly thinking about either the forced apology or the other non-forced apology. If you've had any experience looking at any correlation between the jury saying that they want an apology and reducing punitive damages.
You may have things to say about forgiveness. I'll comment on punitive damages. John, Rob, and I have done a couple of different studies looking at maybe there are trade-offs between apologies and punitive damages, and we're still trying to sort out what exactly we're finding. We haven't found a clear pattern so that we can say, yes, if the wrongdoer apologizes, the juror awards less in punitive damages. In fact, we've got a couple of conditions where it looks like the jurors award more. So stay tuned, I guess, is the best I can say. It seems like it's possible, given some of the goal management principles, that they ought to trade off. But maybe if they're serving different goals, we wouldn't expect them to trade off. So we're attempting to sort that out. I don't know if John wants to add. That's where we are.
Well, I just want to, I mean, there's a huge trend now in the field of psychology to promote forgiveness in psychotherapy and even unilateral forgiveness, and I worry about that moving over into the court system. Though I think that when there are, when you make possible the expression of remorse, or more possible the expression of remorse, or the potential for apology within those systems, you might be able then to evoke forgiving feelings in jurors.
A question for Jennifer and also for Tony, but for Jennifer, in the conditions where the corporation had contemplated the costs, did you ask the participants whether they thought that the corporation had, they mistrusted the data on which the corporation purported to rely? And I asked that because it ties into a theme that Dan articulated this morning.
No, we didn't ask them anything about sort of whether or not they accepted the analysis that the company did. And I don't think we asked anything else that sort of speaks to that issue.
I guess I'm just wondering if you could tease out the possible prototype of the bad, deceitful corporation effect from the taboo trade-off effect.
I don't think so, and as I sort of said in the talk, there are a number of possible explanations. I only talked about the one that's suggested by taboo trade-offs. There's a couple of others for which we don't have any data to assess whether or not they're operating. One possibility is that the jurors do the analysis after the fact differently than the corporation did it before the fact. So now they're not trading off possible risk against cost. Right now they're comparing the lost life to what the cost would be, and we don't have any data to speak to that yet.
I also have a question for Jennifer. I mean, I'm not. I guess I just want to provoke a response from you because I'm thinking about the expressive significance of using monetary exactions, and it seems to me that the feasibility of that is constrained by framing effects in an interesting way. this is unproblematic as a gesture to express condemnation in civil law, punitive damages, but it's unsatisfying and problematic in criminal law, where people have a kind of anti-commodification reaction to fines. You're commodifying the wrongdoing of the criminal. You're putting a price tag on the behavior, or imprisonment is the way to express condemnation. That's incommensurable with cash, so we can't substitute that for. And I do think that there's a framing issue. Fines are framed with imprisonment in the criminal setting, and because imprisonment is so unambiguously condemnatory, the fine has that connotation. Here, the fine in the punitive damages are framed with compensatory, so they seem, in relation to that, unambiguously to be expressing denunciation. But then, when you say you're doing this with the apologies, and I'm wondering too that seems to shift the frame. And I'm wondering if there's a way. I mean, to test the framing hypothesis, is there a way to frame the punitive damages as an alternative to something that's unambiguously condemnatory? I mean, there's a shaming element to the forced apology. But in criminal law, there are even more dramatic shaming rituals, that not just forced contrition, but other things that are even more dramatically degrading. And I'm wondering if that were somehow put before the jury, well, not stocks, but the signs, and so it's a trend. And actually, people don't find that to be an inadequate substitute for imprisonment. I'm wondering if you tried experiments like that, could that mute the appropriateness that people see of punitive damages as an expressive gesture?
So if they had alternatives that would substitute better than John, if you want to jump in? Or,
Well, I just want to give a historical perspective on this, which is in Germany, actually, when there was a system by which gentlemen could sue other gentlemen for insult, which, as you know from Jim Whitman, is quite the active part of European civil law for punitive damages. There was an interesting movement at the very end of the 19th century to make this more efficient, as more members of the middle class were doing this, to allow the defendant to purchase an advertisement to take out the apology, and then just to give them the money that would cost to take out the advertisement. And that was, of course, then very controversial, because some traditionalists thought that this violated the expressive function that you're describing.
Yeah, but money does have meaning that's sensitive to context, and so, I mean, we don't have any problem thinking of punitive damages. So I'm just wondering that maybe if we had a problem with punitive damages, a lot of people think it's inefficient to have punitive damages as the mechanism for expressing condemnation, we could try to frame it with something that satisfied the expressive goal without the kind of, just without the bad economic consequences of.
well, and it might be possible too that punitive damages better serve the expressive function in certain kinds of cases. So maybe in sort of the cost-benefit analyses kind of cases, the defendant has sort of demonstrated to the jurors that money's what speaks here, and so it's notably expressive in that context, whereas it might not be as expressive in another context, and there might be other alternatives.
Let's start over there.
Yeah, I'd like to pursue this forgiveness business for just a moment. I've always thought that the victim was the only person who was entitled to forgive the perpetrator of some damage to the victim. And it strikes me as being extremely odd that one would think of a jury as forgiving the perpetrator in any way at all. I found it odd for anybody to presume to forgive the person who's hurt me for the hurt that was done to me, other than myself. So I wonder if you could explain how that works.
I don't know if I guess what I want to say is I don't think I mean to suggest that the jury is engaging in forgiveness here. And that may in fact explain why apology and punitive damages don't look like they're trading off against each other. It's not that the jury is saying you've offered the apology, therefore we forgive you on behalf of the community, the victim, anyone, and therefore we will sanction you differently. Because you may be right that the victim is the only person who has standing to offer and feel forgiveness of the wrongdoer.
Except that jurors, if they're representing society in some way, and especially in the cases you present, that's their, their goal. Society has been harmed by that sort of thinking.
Well,
Then
if I can just follow
I'm not
up.
saying they should. I'm saying that those kinds of feelings can be evoked.
I don't see that in this kind of case, in a civil case, that the jurors represent society in dealing with a particular issue. They are there to judge between the plaintiff and the defendant, and they are simply there as sort of like arbitrators, not moral arbitrators.
But part of what goes into their decision is some societal judgment about whether there's been negligence. So what is an acceptable degree of risk? I think Jeff's paper this afternoon might speak to that a little bit. That the social norms of the community are, now you're on the spot, Jeff, part of what jurors take into account.
I wanted to go to the issue of not only coerced apologies, but just coerced verbalizations in the criminal area. And as a former practitioner, I've had this experience where a person was charged with multiple counts of rape and sodomy and was willing to plead guilty and was willing to go to jail for a long time, but had a major problem allocuting to the crime in court. And particularly in a particular case where a person was charged with about 120 counts, the prosecutor, in order for this person to earn the plea bargain, the prosecutor demanded the defendant actually admit to specific acts relating to about 30 or 40 victims over time. And the defendant refused to plead guilty, even though he said, I can do the time upstate on my head. But he had a major problem in the coerced statement of responsibility, which did not include an apology, but nevertheless, this coerced verbalization thing became very interesting. And I wonder how that factors in. I think the prosecutor was right in one sense, that he was probably expressing what society would have wanted out of that. Society generally doesn't like plea bargains, particularly in outrageous cases. If there's going to be a plea bargain, then at least society wants to see that expression. And interestingly enough, that was exactly what the defendant was had most problems.
This question sort of question comment for Jen and then something for Tony. Jennifer, I wonder if I've always been struck by Viscusi's cost-benefit study as kind of a dumb presentation of cost-benefit analysis to the jury. That, oh yes, we traded off life for money. Yeah, we like doing that here at X Motor Company. I mean, in a sense, it can't be realistic because we know every car has cost-benefit, every bridge, every building, I mean, jurors must know this, that at least implicitly there's cost-benefit analysis going into every trapping of modern life that they engage in. And there's sort of two follow-ups. And one is it just that they don't like seeing how their sausages are made? Or is it that nobody ever explains to them why and how cost-benefit analysis is being done? Even in that sort of classic Ford Pinto case, Ford never explains why they're doing cost-benefit or how they design the cars. They're not taking the jurors behind this. They're saying, oh yeah, look, $60,000 a life. That's the deal at Ford Motor Company. They never tell you why they're doing it. If they explained it, I wonder if it wouldn't be different. But which is kind of. But maybe you have data that'll speak to it.
I don't have data, but I think probably both a little bit. One thing is that we all implicitly know that there are limits on safety, and we implicitly make those trade-offs all the time. It's the making it explicit that jurors react to. And second, it may partly be that they're not thinking through the calculus in the same way that someone doing the cost-benefit analysis for the corporation may be doing. Rob tells about his public policy students who, even once he can get them to understand the analysis and grudgingly admit that it's okay to do, still have that visceral reaction to explicitly making those trade-offs.
But I'd sort of urge you to find data in which there's a condition in which the cost-benefit analysis is accepted by the jury. That way we know the limiting principles behind the basic phenomena that people react badly to it. That it can't be universally true. That there must be circumstances under which it'd be accepted. And then you'd really understand the phenomena that's going on. To Tony, I thought your paper was really wonderful. And I wonder to what extent it isn't... you kept talking about fault, isn't it about, look, if you're a smoker and you die of lung cancer, we got two people at fault. You for smoking and the tobacco company for selling you the cigarette. And to what extent there isn't, in a sense, in the 50s that, you know, nobody even thought about fault of the smoking company. So when Fleming James writes about essentially no fault, what he kind of means is holding the cigarette company. I mean, we just say everybody's at fault, and that's just the way it is. And that Ralph Nader's modern version is, no, we have more, you know, we've thought a lot about this in 30, 40 years. We blame the smoking, the tobacco company instead of the smokers. They're both at fault, sure, but we blame someone differently. And that may be an incoherent, half-baked comment, but it's, you know, there's something missing. I mean, there seems to have been another move, which is that I don't know whether Fleming James would have even considered the prospect of fault the way Carl Bogus does, in which a tobacco company is at fault or Ford is at fault, and you know, and fault is sort of socialized in a sense, and that maybe he just had no conception of that. Had he thought of that and thought that that was an acceptable intellectual idea, he might have thought fault was a pretty good idea and not so immature after all. I don't know.
Well, there's a lot there. I agree with you. There's something missing in the presentation of 25 minutes. I couldn't get to the whole second half of the paper. There's a reason why I started with Ralph Nader's comments about no-fault auto insurance, because he's more well known for his comments about corporate crime. But what I want to argue here is that there's in fact a continuity between the mental construct that leads you to conclude that a great deal of tort resources, this tort system's total resources, should be dedicated towards identifying intentional torts. But that's really what Nader's arguing. He's saying that we should be dedicating a great deal of our tort resources to discovering intentional torts. But the reason for this actually is continuous with a deeper belief that someone like Nader, I'm not picking on him personally now, okay? I mean, we can talk about Atla in general, that in fact,